Stop and listen carefully. The biggest danger in the new earned settlement plan is not only changing the rules for migrants already here. The bigger danger is building a future where lawful migrants can stay temporary for 10, 15, or even 20 years. That is not integration. That is long-term insecurity. Watch this carefully, because a lot of people are getting one crucial point wrong. The government's earned settlement plan is not just controversial because it may hit people already in the UK. It is controversial because it pushed through. It could permanently redesign immigration in a way that keeps families, workers, and even children in limbo for longer than this country has traditionally required. And here is the key point. Most of this is still proposal, not final law. The white paper itself did not change the law. The Home Secretary later said the norm should move from 5 years to 10, with some people settling earlier and others later. But Parliament has been clear that many details are still subject to consultation and not yet finalized. So let us separate law from politics. What has already changed? The government has already legislated for a higher English language standard for settlement, moving to B2 for applications made on or after 26th of March 2027. What has not yet happened? The wider earned settlement structure, including the proposed 10 years default route. The proposed 15-year baseline for medium-skilled workers and the proposed 20 years baseline for refugees. That remains part of reform package that is still being worked through. Parliament also noted that some people could face waits of up to 30 years under the consultation model. So when you hear sweeping headlines, slow down and ask, is this final law, a proposal, or political messaging? Laws are changing fast and experience matters now more than ever. Hello everyone, my name is Sajjad Kayani with 2 decades of expertise in UK human rights, immigration, family and civil litigation. I'm here to give you the facts you won't find anywhere else. So now let's get started. First thing first, let us deal with the retrospective issue. In my view, moving the goalposts for people who came here lawfully under one system is plainly wrong. Families made life-changing decisions on the basis of a 5-year pathway. They accepted jobs, moved children into British schools, paid repeated visa fee, and built their future around legitimate expectations that the framework would at least be staying. IPPR estimated that about 1.35 million people already en routes to settlement could be affected by longer default periods. And around 23% of that cohort, roughly 309,000, are children. Sorry. That is not just a small technical adjustment. That is major fairness issue affecting real families already rooted here. But here is the twist. Retrospective change is wrong. Yes. Yet the perspective change may be even more serious. Why? Because the retrospective group is finite. It is defined cohort. the prospective system would shape the UK for years to come. Parliament's Home Affairs Committee said the standard route would move from 5 years to 10 years, and that the UK would become an outlier among most high-income countries, where 5 years is usually the norm for people who have a route to settlement. So, what that means for you? That means the real long-term story is not just fairness for those already here. It is the kind of country, Britain, that becomes for everyone arriving in future. Now this matters because settlement is not just a piece of paper. Settlement tells people whether this country wants them to invest, belong, and stay. The Home Affairs Committee received extensive evidence that prolonged temporary status risk harming integration, community participation, and long-term commitment to the United Kingdom. The committee expressly noted evidence that permanent status and citizenship improve economic and social integration, including helping people progress in their careers and earn more. So when government says a longer route may promote contribution, the evidence Parliament heard suggests the overall package may do the opposite. And the human impact on children is profound. The committee warned that many children could spend most of their childhood on temporary status. It also said extending routes to settlement is likely to increase the number of young people who are not eligible for home fee status at universities, which could mean delaying or missing higher education altogether. IPPR made the same point. Prolonged insecurity can limit access to student finance, stable employment, and long-term planning. So what does this mean in real life? It means a child can grow up in Britain, go to British schools, speak like every other British teenager, and then reach adulthood only to be treated by the system as still temporary. There is another issue that deserves much more attention: workers' rights. Most sponsored workers are not just tied up to the United Kingdom, they are tied to a particular employer. Parliament's Public Accounts Committee said there is widespread evidence of workers suffering debt bondage, excessive hours, and exploitative conditions under the sponsorship model. The Work Rights Center found that nearly 2/3 of surveyed migrant case workers reported an alleged employment rights breach in the previous 12 months, and more than a third did not complain. Citizen Advice explains the pressure very simply. If sponsorship ends, a worker will usually have only 60 days. For the remainder of their leave, if shorter, to secure a new route or leave the country. And here is the key point. A 5-year tied route is already hard. A 10 or 15 years tied route changes the balance of power even more sharply in favor of the employer. That is precisely why the Home Affairs Committee recommended more flexible visa arrangements for workers placed on long routes to settlement. So, There are not dependents on one, they are not only dependent on one employer indefinitely. In plain English, if government insists on longer waits for ILR, then workers should at least gain freedom to move employers after a defined period. That is not a radical demand. That is basic protection against structural exploitation. Now, let us turn to the money argument, because this is where the public debate often becomes misleading. In her speech on 5th of March this year, the Home Secretary Shabana Mahmood said that if the rules were not applied to those already here, there would be a £10 billion drain on public finances. Referring to lower skilled workers and their dependents who arrived between 2022 and 2024. But that case is heavily contested. Professor Jonathan Portis told Parliament that the cost of extending the ILR period would substantially outweigh any physical benefits from reduced benefit access and higher visa fee. And the Migration Advisory Committee's own modelling found that the skilled worker cohort arriving in 2022 to 2023 would make a present value net physical contribution of around £47 billion over their lifetime. So the physical case is not settled here. It is disputed, and viewers should be told that honestly. One careful legal point here: do not confuse the wider earned settlement proposals with every March 2026 rule change. For example, separate refugee rule changes have already taken effect, including shorter initial grants and active review, as most of you must have been aware of the fact, because I have recorded my previous videos on that. And that is including, as I said, shorter initial grants and active review. But the headline 20 years refugee settlement concept referred to in the parliamentary report belongs to the proposed earned settlement architecture, not a final across the board rule already in force. That distinction matters because good legal advice begins by identifying what is already law, what is draft policy, and what is still politically contested. So what does this mean for you? First, do not assume a headline equals law. Secondly, if you are already on a route to settlement, keep a close eye on transitional protection. Thirdly, if your settlement timing may fall on or after 26th of March 2027, plan now for the higher B2 English requirement. Fourthly, if you are sponsored worker, think strategically. If you are a sponsored worker, then you have to think about the extension timing, employer changes, family applications, and what happens if a child is approaching 18 or university age. And fifthly, get tailored advice before making irreversible decisions. A fair system should reward lawful contribution, not punish people for building a life by the rules. Let me leave you with this. A country does not build cohesion by telling lawful workers and their children to remain temporary for a decade or more. Stability builds integration. Fairness builds trust, and trust builds stronger communities. Subscribe the channel if you find it helpful. Leave your question in comments and I will revert. See you soon.